So, in brief, on the final day of trial, the judge decided to reserve his judgment and not give it at trial. Most likely this is because he wants to very carefully review the evidence and give a written judgment. When that written judgment is finished, he's going to contact us and give us 4 days to choose from to either attend by telephone or come into the courtroom to receive his judgment. If we come into the courtroom to receive his judgment or manage to have somebody to represent us to receive his judgment, then the judgment will be available to be viewed by the public. If we do it by teleconference, then it will be in an exclusive, the doors will be closed and no one will be able to attend but us. So we'll keep you posted on when the judgment is coming and whether or not we do it by teleconference or if we manage to get a representative so people from the public can attend. At this point, our work is done. We will not need to return. We'll not need to have any witnesses return. All of the evidence has been submitted. The closing summation statements have been submitted, so it's done. We're not going to have to do another fundraiser to get more witnesses there or anything like that. We may have to do a fundraiser to get the trial transcript, which will be very expensive. A 5 to 7 day trial. It's basically for something like 42 cents a word, so it could be $1,500 to order the transcript, plus another $500 for the final, to receive the final judgment, the written judgment from the court. So aside from that, it's over. We're done. Our work is done. We've brought this to the point where it can receive a judgment. And this is going to be very brief. I'm going to give you a few details on what occurred, because right now we're still working on getting ourselves to the UK. We have fully funded our Amsterdam meetup, and we're now working on funding our Manchester meetup. And if you're interested in helping out with that, www.feedthebadger, just select Badgers Take Britain, Take 2. And now on to those details as promised. So, for those of you who don't know, I'm suing the Mary Sue and the Calgary Expo after the Calgary Expo breached their contract with me and kicked me out of the 2015 Calgary Comics and Entertainment Expo. And then the Mary Sue published a bunch of falsehoods about why. They allege that I infiltrated the convention under a false name when my exhibitor application clearly stated my name and Honey Badger Brigade as my company name. They also alleged I harassed panelists in a Women into Comics panel. When I asked to speak to a topic, the panelists brought up and was granted permission, and further when they asked that I cede the floor to others, I did. So at no time was I outside of the control of the panel moderator. We initiated this lawsuit almost 2.5 years ago, and it has taken all that time for the Calgary Expo to finally come clean that it wasn't me lying on a contract, infiltrating the convention, or allegedly harassing panelists that got me kicked out. It was ultimately two things. One, the number of complaints they received. The operations manager told the clerk that even if every complaint had been found false, the number of them would have gotten me kicked out regardless. So he would have been okay with 2 or 3. But the fact that it was 25 Twitter complaints, that was too many. And they could have all been false, but the fact that there were 25 of them, that was the final straw. And finally, even if I had received no complaints whatsoever, the operations manager informed the court that I would have been kicked out due to my association with Gamergate and with men's rights activists, as well as my beliefs. Even though, when asked, he couldn't specify a single hateful belief. He just said it was obvious from the people we disagree with. This last point confirms what we alleged in our original pleadings to the court. At the time, we had no way to absolutely confirm that it was my associations with Gamergate and men's rights that got me kicked out. After the defense's testimony, that was confirmed. After my direct testimony and the testimony of our witnesses and the confession of the Calgary Expo's operational manager, Harry, our legal agent, made his summation, pointing out that our evidence I hadn't infiltrated the convention or harassed panelists, that the operations manager couldn't identify a specific hateful belief Honey Badger Brigade held, and finally he asked the judge to prevent monopolistic corporations that advertise broadly to the public from discriminating against people for having minority views. This request, if granted, would set a very significant precedent. Just to get into that last point a bit, This precedent wouldn't apply to mom-and-pop bakeries or any other company with reasonable competition, but only to those companies that choke off access to a service, such as airports or malls, or choke off access to a marketplace, such as selling comics and genre art in Western Canada, or distributing online media. It would also only apply to those businesses that offer a broad invitation to the public, not to those businesses who specify in their invitation that certain groups of people need not apply for whatever reason. In other words, if you want to be exclusionary, you have to be upfront about it so that people can decide if they want to associate with you. This was the final item addressed in Harry's summation. On the first day, the court clerk suggested that the judge was ready to render his verdict on the second day of trial. After Harry made his request that the judge prevent Calgary Expo from excluding me from its events based on my views, the judge asked clarifying questions and decided to reserve his judgment. The court clerk later said that the judge would likely be ordering up transcripts of the trial to review them very carefully. I'd also like to point out that it was the defense's testimony that set up the possibility of this precedent. Had he maintained that the Calgary Expo evicted us for other reasons, we would not have had grounds for Harry to request that the judge prevent the Calgary Expo from discriminating against me and people with political views it disagrees with in the future. This is why I was circumspect on a lot of the details of our strategy, or even the exact nature of the precedent we would be pursuing. In conclusion, the actual judgment may take weeks or months, but it's good that the judge is taking his time to get it right. We've set before him the very best case we could, and with the help of the defense, set up a potential precedent-setting judgment against monopolistic corporations who want to practice discrimination in stealth mode. This trial has been a bit of a gong show, not on the part of Harry Capito, our legal agent, or the judge or the court, but on the part of the defendant. Karen will be detailing all of their shenanigans in an update video of epic length, and I'll leave the specifics to her. I did what I set out to do. I brought this case to a judgment. Now, where it goes is out of my hands. It's up to the judge what he decides. But I did the very best I could. And that's that. I did my job.